and welcome to all our friends. It's a pleasure to have you as well. We will be recording the event so that if you want to recap on the next hour, it'll be available on our website fairly soon. It's my pleasure to introduce Ardi, a good friend of the Balfour Project. Ardi is Assistant Professor of Law at Queen's University in Kingston, Ontario, Canada, and the author of a very recent book entitled The United Nations and the Question of Palestine, a highly relevant book that Ardi will spend a part of his time discussing. And Ardi has all the credentials needed to write about the UN and Palestine, having served in senior policy positions and legal positions with both UNRWA and the UN High Commission for Refugees. He's a member of the UN Human Rights Council Commission of Inquiry investigating violations of international humanitarian law and international human rights law in the Yemen civil war. Directly relevant to Israel-Palestine, Ardi is a legal counsel to the State of Palestine in the case before the International Court of Justice on the legal. So Ardi will say something about the two cases before the ICJ currently, particularly the advisory opinion awaited on the relevance of or the legality or illegality of the Israeli occupation of 1967, and about the ICC chief prosecutor's request for arrest warrants for leaders of Hamas and for Israel's prime and defense ministers. Ardi will speak for about 15 or 20 minutes, and then our chair, Andrew Whitley, and I will have a short discussion with him before Evelyn comes in to transmit to Ardi your questions for him written into the chat, and we'll have about half an hour for Q&A. And with that, over to you, Ardi, and welcome to the Friends of the Balfour Project.
Sir Vincent, thank you so very much for that very generous introduction. And I should like to begin by thanking you, Evelyn, and of course, Andrew, a longtime friend, colleague, former colleague at UNRWA, for the opportunity to address you and your important community. Let us, I suppose, begin with the book that I've just published. Cambridge University Press published the book in 2023, November, entitled The United Nations and the Question of Palestine, Rule by Law and the Structure of International Legal Subalternity. And it is a book that I'd been working on for a number of years. It emanates from doctoral research I conducted at Cambridge about 8 years ago or so, or beginning in 2016, but it emanates from far longer than that. My time spent in Palestine working with UNRWA and on the question of Palestine for many, many years. In that time, I had often asked myself, what was the role of the UN in the creation, the maintenance of Palestine's Palestine problem? And so the book focuses on that. It's a critical international legal study on the UN's record, on the basis of what the UN record shows the UN has done or not done on the question of Palestine, and tries to help us better understand how the UN can be better, more in line with international law, but also why we are where we are today. It, to be sure, doesn't assign full blame for the question of Palestine as it exists today to the United Nations, but what it does try to do is try and situate the UN's special role and unique role. So the starting point is that the UN holds itself out to the international community as being the standard bearer of the rule of law, of international law, right? And your viewers will recognize what that means, the rule of law, where international law is universally applicable to all parties, all subject to the international legal system, regardless of their station in the position, rather their position or station in the world. And where, law, everyone is held to the same standard. And then I ask, well, what does the UN record show about the UN's positions on key moments in the question of Palestine from 1947 to the present? And what does that record show about whether or not the UN's moves, actions taken or not taken at these key moments, whether or not that is consistent, whether or not the UN was consistent with international law? And I take a critical view of it. So I begin by looking at 1947 and the partition plan of the General Assembly of November 29, 1947. And then I move into the unique institutional and normative framework created to manage the fallout of the 1948 conflict, being the Palestinian refugee problem, which was produced by the United Nations, this unique framework, being UNRWA and the UNCCP, or the United Nations Conciliation Commission for Palestine, on the one hand, and how that differs from UNHCR on the other. And then I move forward in time to deal with how the UN has managed the question of Israel's continued presence in the occupied Palestinian territory, the occupation since 1967. And then I move finally to look at how the UN has managed Palestine's request for membership in the organization as a member state of the United Nations. And you'll note that over time, from 1947 to the very present, Palestine suffers the effects of what I call the international legal subaltern condition, or international legal subalternity. It's a mouthful, but the essence of it is this: that for the subaltern groups in the world, those on the receiving end of power, those who are the exact opposite of hegemonic power, strong, hegemonic force, law is constantly held out, international law is constantly held out to these groups as being the only means through which they can maintain justice, they can obtain rather justice, freedom, etc. And if only they abide by those things, things will be okay. They will have justice at some point or another. And notwithstanding the UN's holding out to these subaltern groups, in this case, the Palestinians, of international law as the only means through which they can attain justice, through the very action, paradoxically, of the United Nations at each of these moments, the goalposts constantly shift on the subaltern groups. And so I argue that there is this legal subaltern condition that the Palestinians embody, and not uniquely them. There are other subaltern groups, many in the world, non-self-governing groups, refugees, indigenous peoples, you name it. You can find legal subalterns wherever you look. But that's the general frame. And so what I try and do is look at and see what each of these moments in time and what the UN record on each of these moments in time show us about how the UN has in fact operated, notwithstanding itself holding itself out as being the standard bearer of the rules-based international legal order, and what that means for the UN, and what it means for the Palestinians as legal subalterns, and ultimately what it means for us as a global community that strives for the rule of law rather than what I call the rule by law, where law is used, abused, selectively applied with the aim typically of a few hegemonic states, sometimes one, but oftentimes more than one, to use law as a tool to bludgeon, and in this case, to bludgeon the global South as embodied by the Palestinians. The most important chapter of the book, I would say, is the one that deals with the 1947 partition resolution. I spent a great deal of time focused on that because there you have an action taken by the General Assembly, which is a different General Assembly than what we have today. It's a Western-dominated General Assembly immediately after World War II, rather, who is telling the world through the creation of this new organization, the United Nations, that human rights matter, that we, the peoples, I'm now paraphrasing the UN Charter, we, the peoples, will save future generations from the scourge of war by focusing and exalting and protecting human rights, including self-determination of peoples and other such. So that Western-dominated General Assembly supposedly acting consistently with what it claims its values are in the UN Charter, but then doing something altogether different with its decision to recommend partition on terms that, on their face, and the UN record is very clear on this, were clearly violative of basic principles of international law as they applied, for instance, to the self-determination of peoples in Class A mandated territories. So if you look at the terms of the partition resolution, you'll see that about 56% of the territory was allotted to the Jewish settler population. then numbering only 1/3 of the population of the country. And at the time, the Jewish community of Palestine only owned about 5.6% of the territory of Palestine, so had registered ownership of it. And notwithstanding that, they got 56% of the total as recommended by the General Assembly. More than that, even more egregious, if you like, the population of the purported Jewish state that would be set up in this 56% of historical Palestine was very clearly outnumbered. That is to say, there was 10,000 more Palestinian Arabs, 509,000 roughly, Palestinian Arabs in the purported Jewish state or the recommended Jewish state than there would be Jewish Palestinians or persons of the Jewish faith living in the Jewish state. So from the off, on the basis of the terms of the partition resolution, you have a minority government established in a Jewish state, which is an ethno-democratic state ostensibly. And even as the same General Assembly says that both states established through the partition need to be democratic and ensure a rule of law and so on. So you have these inconsistencies. And of course, the partition plan is followed after its passage, maybe 3 days later, by a civil war, which breaks out, the first 6 months of which produces 300,000 Palestinian refugees. And then once the international armed conflict begins with the establishment of the State of Israel on the 15th of May, 1948, you have another about 12 months of war, during which time about another 450,000 Palestinian Arabs are ethnically cleansed from what became the State of Israel. And that is followed by legislation that the State of Israel produces, which is aimed at usurping territory and control over territory and ownership from that territory of the Palestinian refugees who have now been expelled and forbidden from returning simply because they're not Jewish. All of this legislated in Israeli law and so on. I look at how the UN managed that in its dealing and its creation of the Palestine refugee problem and its creation of UNRWA and the UNCCP, as I said earlier, the Conciliation Commission for Palestine, and its aim of finding a quote unquote durable solution for the Palestinian refugees. And yet at every time, every moment they get a chance, their actions are inconsistent with what international law requires. I'll just give you a bit here. I can't cover the whole book, but on the refugee problem, it's a basic principle of international law, the law on nationality, that where there is a change in sovereignty over any territory, nationality follows the sovereign, right? So new sovereigns that emerge in a territory cannot wholly depopulate that territory by denationalizing the population, by removing the nationality of that territory of its population. This would produce absurd results where people are ethnically cleansed and having to find refuge in other countries, which is exactly what took place in 1948, 49. All this to say that the UN, notwithstanding its general prohibition on denationalization of a population following the change of sovereignty, instead of withholding Israeli membership in the organization, argues that we should try and mediate a resolution between the Arab states and Israel over the general issues that are outstanding before them, rather than the specific issue of refugee restitution, return, etc., and thereby giving rise to a problem, the Palestine refugee problem, which continues to fester some 75 years on through institutions which are doing a great job, to be sure. UNRWA in particular, I was legal counsel there for many years, doing a great job in trying to manage the humanitarian fallout, but without looking at the key issues, including how international law requires that they be resolved, of durable solutions for this population. One could go on, and I will just offer one last point as an example of this legal subaltern condition, which can then serve as a segue into a conversation perhaps that I could have with you, Sir Vincent and Andrew. And that is another aspect, which is how the UN has managed Israel's continued presence in the occupied Palestinian territory since 1967. Your listeners will know, and your viewers will know, that since 1967, Israel has been in belligerent occupation of the remnants of Palestine, being the occupied Palestinian territory, some 22% of the historical patrimony of the Palestinian people in the West Bank, East Jerusalem and the Gaza Strip. And one thing you should know is that international law requires that occupation be temporary, a temporary condition, during which the occupying power is not sovereign and cannot by definition be sovereign in that territory by virtue of a general prohibition on the acquisition of territory through the threat or use of force. And notwithstanding the temporary nature of occupation and the fact that the occupying power can never be sovereign, Israel has pursued an occupation that has now lasted some 57 years, over a half century, during which time it has been very clear. The public record, including the UN record, has been very clear that Israel wants to colonize and is colonizing that territory. It refuses to establish or allow the establishment of a Palestinian state in that territory. It claims that only the Jewish people have a right, exclusive right to sovereignty in that territory, and so on. And so I asked the question, why is it that the United Nations has spent decades documenting these violations of human rights and humanitarian law in the occupied Palestinian territory, among which settlements are unlawful, torture is unlawful, a usurpation of private property also unlawful. All these discrete actions of the occupying power are illegal, but the UN has yet to make a finding on the legality, or in my view, the illegality of Israel's very presence in the territory, that the regime itself that gives rise to these discrete violations, why has the UN not said that this is illegal, the regime itself? And so I look at the UN record on that, and despite a few General Assembly and Economic and Social Council resolutions that date from the 90s and the early 80s and late 70s, the UN has remained silent on this, and so I argue that the occupation has become illegal for its violation of three Jus Cogens norms, peremptory norms of international law, derogation from which is not permitted. First, territorial conquest is never permitted under any circumstances. Israel is conquering that territory, and openly so. Second, the obligation to respect the people's right to self-determination. Israel is violating a people's right to self-determination, that people being the Palestinian people in the occupied Palestinian territory. And third, the obligation to refrain from imposing regimes of racial domination, exploitation, and subjugation, being apartheid. And I ask, well, why hasn't the UN required the end of the occupation? Because these norms are being violated and they're peremptory. They do not admit of any exception. And the regime itself is inextricably connected to their violation. You cannot unscramble the egg, as it were. What gives this issue great prominence in my mind, and as an example of this legal subaltern condition, is the UN has said, look, since 1967, we've documented all of these violations of the occupying power in the territory. And therefore, we hold ourselves out as being progenitors and standard bearers of the rule of law when it comes to Palestine, right? You equate what the UN says on Palestine and the OPT as being consistent with international law. And yet, the UN says the only way that you can end this occupation is to negotiate its end with the occupying power. And that, of course, runs contrary to a basic principle that one cannot negotiate the end of an illegal act. If the occupation is itself unlawful, international law of state responsibility requires that it be ended forthwith and unconditionally, that is, not be subject to negotiation. And so through this research and through the work of others, including the former Special Rapporteur, Michael Link, on the situation of human rights in the occupied Palestinian territory, a number of us have been working on a case at the International Court of Justice, which I've been doing. And in October, I guess December, forgive me, 2022, the General Assembly asked a series of questions to the International Court of Justice, the nub of which is whether or not Israel's continued presence in the occupied territory is unlawful. That's the essence of it. And submissions were made last year and earlier this year, orally in February, and we expect the court to issue its ruling next Friday, as it happens. Today, they issued a notice to the general public indicating that in 1 week, they will provide their opinion on whether or not Israel's occupation that has run 57 years of the occupied Palestinian territory is lawful. And so this, just to wrap up, is an example of two things. One, the omission by the United Nations to deal with the legality of the occupation, despite what its own record demonstrates, is that the occupation is unlawful, right? what accounts for that? And I look into the reasons why that exists, and I interrogate that and demonstrate that this is more of a rule by law situation rather than a rule of law situation. But then I say, look, the subaltern group can use international law counter-hegemonically to push up against this tension and try and produce results in order to ensure that the UN and its principal judicial organ, and more generally, the international community abide by international law. And so this case is a perfect example of the counter-hegemonic use of international law by legal subalterns to try and seek a modicum of justice through international law and make our world a more just place, knowing that the tension between hegemons and subalterns will always be there. It's a fixed feature of the international legal order. I could go on, but I feel I've already gone on for perhaps too long, maybe 15 minutes. So I will stop there and hand it back to you guys.
Thanks very much, Ardi. That was great. You really set the scene very well. Ardi, I want to be the layman. I am a layman. I'm not a legal scholar like you. I don't have your expertise in it. And I want to ask a layman's question. You know very well that the Israelis have consistently argued that this is not occupied territory, it's disputed territory. They say that there was never a legal sovereign in these territories beforehand, despite the fact that Jordan had actually annexed the West Bank and East Jerusalem, and Egypt had military occupation in Gaza. Can you address that particular point, but also go on to explain why is it that the 1949 armistice boundaries, which is what we call the Green Line these days, why is that the basis for the future Palestinian state? Why is that particular line? What's the legal significance of that line for determining what are the future contours of a Palestinian state?
Thank you, Andrew. Great questions. So, yeah, the Israeli position is and has historically been that the territories aren't occupied as such. Because it's a very technical argument. If you look at Article 2 of the Fourth Geneva Convention, which is the main treaty that governs occupied territory, it says it's an IHL treaty, an international humanitarian law treaty. It says that the treaty shall apply to the, quote, territory of high contracting parties. Right? So Israel argues, well, Jordan, who they took the territory from in 1947, forgive me, 49, 47, rather 67. Although it is a high contracting party, the West Bank, including East Jerusalem, was not the territory of a high contracting party. That is to say, Jordan wasn't sovereign in that territory. And therefore, Israel enters the territory that has no sovereign. It's called the missing reversioner thesis. This was done by a fellow called Yehuda Bloom, who taught at the Hebrew University in the mid-70s. And therefore, it can't be occupied territory, and the Fourth Geneva Convention cannot apply to it. This argument has been roundly debunked by pretty much every serious international humanitarian law scholar in the world. Many Israeli legal scholars among them. Eyal Ben-Venisti is a good example of one, and others. And no state on earth agrees with this, with the exception of Israel, who's making the argument. And the reason is simple. If you look at the terms, the territory of a high contracting party, the object and purpose of the use of the term territory, as indicated through the travaux préparatoires, the negotiating documents behind the Fourth Geneva Convention, does not indicate that the states who drafted the Fourth Geneva Convention ever intended to protect the sovereign interests of states who might hold territory. No, the meaning territory of a high contracting party needs to be understood more broadly to include territories of high contracting parties, that is, territories that may not even be their sovereign, under their sovereign control, but are under their effective control, and that is enough. That would be consistent with the object and purpose of international humanitarian law and the law of belligerent occupation being to protect the civilian population in time of war, not to protect the sovereign rights of states in time of war. So that's the long and short response to why the territory is occupied and considered as such by every principal organ of the United Nations, the Security Council, the Secretariat, the International Court of Justice, the General Assembly, the Economic and Social Council, and so on, as well as by the custodian of international humanitarian law, the International Committee of the Red Cross. There's no There is no debate about this. There is a consensus that the occupied Palestinian territory is indeed occupied by Israel, has been since 1967, and that continues to this very day. The 1949 lines, why do we speak of those instead of some other thing like perhaps the 181, Resolution 181 partition plan borders? Well, let's be clear. Armistice lines in international law are not political borders. That's the starting point, right? They're merely lines that are agreed by warring parties to establish a ceasefire or an armistice, better, a long-term ceasefire, if you like, pending the conclusion of a peace deal. But they aren't political borders. So why do we speak of the 1967 lines as being, in effect, a political border for the establishment of two states, one Palestine in the OPT and one Israel in the other? And this is simply through political practice of states. Most importantly, the state of Palestine through the Palestine Liberation Organization and its decision in 1988 to recognize Israel. When it did that in 1988, arguably, they were recognizing Israel within the 67 borders because of the reference at Algiers and Algiers declaration that the PLO gave to establishment of a Palestinian state on the basis of the 1967 lines, so to speak. But who knows, like in the future, when there is, if there is a negotiated resolution, the Palestinians may argue that it should go beyond the 67 lines. It would be a tough one for them to do by virtue of the many, many hundreds of public statements they've made over many, many years to this effect. But in effect, the answer is we refer to the 67 lines because of political practice of states, most particularly the state impacted being the state of Palestine and their political representatives through the Palestine Liberation Organization.
You not put much weight on Resolution 242 passed after the 67 war?
No, the 242 is there, and it affirms basic principles of international law, the most important of which I've set out earlier when I was quickly discussing the ICJ case, the inadmissibility of the acquisition of territory through threat or use of force, is important. Don't get me wrong, but it doesn't create the basis. What's more important under international law, Andrew, is not what the Security Council has to say on that. And they don't say expressly that there should be a state of Palestine established on the 67 lines. It's rather what is more expressly stated by those parties who are directly impacted, being the Palestinians themselves. This is a position that one would call the principle of acquiescence in international law. Where states acquiesce in certain things, they can create legal obligations that bind them. And the same holds true for Israel, right? So Israel says, well, we have a state. It's based on 181. Why have they gone beyond 181? Why have they gone beyond the partition plan? Now they're claiming sovereignty in the whole of the land between the river and the sea. And yet they've held themselves out as well to the rest of the international community as being law-abiding. Are there illegal actions? Do their illegal actions cut away at representations that they've made and which others, the Palestinians, have adhered to their detriment? Those are big questions that deals with issues of estoppel, acquiescence. International law obligations can flow from these things. But the long and the short of it is not to complicate. The international consensus is clear. Two states living side by side in peace and security on the basis of the 67 lines. We know that's the line. On the other hand, we know what the occupying power is doing. And now, of course, in the middle of a plausible genocide, it's gotten as worse as it can be.
Let's bring in Vincent here. Vincent, not all of our friends may know that you were Consul General in Jerusalem, in effect the ambassador to the Palestinians, but you were, and therefore had to deal with these issues on a day-to-day basis. We don't have to pick up exactly where Ardi finished just now, but are there other issues that you think are pertinent that you would like to raise for our discussion?
I've got two. Thank you, Andrew. I've got two. One is on the issue of self-determination of the Palestinian people. Back in 1999, the European Council, with Tony Blair as representing the UK, issued a statement about self-determination, saying that it was a right and not something that could be vetoed by anybody, including the option of a state. That was 1999, if you like, the tail end of Oslo. And I think I'd like you to say something, Ardi, about that equation of the right of self-determination for the people, the Palestinian people, and the established recognition of the state of Israel, the comparator, if you like, between those two. What I'm trying to say is the state of Israel is an established fact. The right of self-determination of the Palestinian people is an established fact. Equating them would lead to what you have just said, which is two states existing side by side. And I guess my leading question is why haven't we got there yet? Second question is more topical in the sense that it's about what our immediately previous government appears to have done in the case of alleged war crimes by Hamas and by Israeli political leaders. We read in the papers that the Sunak government has sought to intervene with the ICC judges to argue that they should exercise their discretion not to issue warrants against those protagonists, particularly the Israelis, on the grounds that Oslo somehow precludes Palestinians from prosecuting, and therefore the ICC should do the same. So I wonder if you could comment on those two.
Sure, absolutely. Thank you very much, Sir Vincent. On self-determination, you're right. The people of Palestine have had their right to self-determination repeatedly recognized by the international community through the principal organs of the United Nations, the plenary body, especially of the UN, the General Assembly, for decades. And so there is no question. I'll paraphrase the International Court of Justice in 2004. They say the existence of the people of Palestine and their right to self-determination is no longer in issue. And so the only issue is, how do the people of Palestine exercise their right to self-determination in their self-determination unit, being at the very least the occupied Palestinian territory? And that is the fundamental issue before us, because it is being encumbered, violated by a bad faith occupying power, being Israel, which claims exclusive sovereignty in the whole of the occupied Palestinian territory. And so in the end, it's almost, in a sense, now the ball is in the court of the international community, right? The Israelis are publicly, very openly colonizing that territory and claiming that territory for themselves. The question is, what is the international community going to do about it? That's why the advisory opinion, which will be issued by the ICJ next Friday, is so very strategically, structurally important and politically important. Because if the court does rule that Israel's very presence in the whole of the occupied Palestinian territory is in and of itself an internationally wrongful act, an illegality, then its end must be made, it cannot be made subject to negotiation. Israel will be bound to end their presence in that territory unilaterally, immediately, unconditionally. And then the real question is, well, the burden will shift to the third states, to the international community. What are they going to do about it to require that Israel withdraw from the territory? As to Israel's the right of the Israeli people to self-determination, they have that right. That's established. They exercise that right, and so on. And it's often extremely important to remind states, especially those that are being lobbied to recognize the state of Palestine in the OPT, that the recognition of the state of Palestine has nothing to do and has no implication at all on Israel, on its existence, on its people's right to self-determination, or the existence of that right. None at all. The only thing it does recognize and affirms, which is a requirement of third states, is to affirm and recognize that Israel is not Palestine, that Israel cannot be sovereign in the occupied Palestinian territory, is not sovereign in the occupied Palestinian territory, and that if there is to be a two-state solution, that there's no rhyme or reason why states shouldn't recognize the state of Palestine and help those states arrive at a conclusion and a resolution based on international law. Might sound like pie in the sky, given what we see on the ground today, to be sure. I acknowledge that. The occupying power is very clearly engaged in an ethnic cleansing campaign in the Gaza Strip. and in the West Bank, including East Jerusalem, and they will not let up unless third states impose a cost on them, unless a cost can be imposed on them politically, economically, culturally, and so on, including through the use of multilateral organs like the ICJ, the GA, the General Assembly, and so on. So this is where the fight is, if you like, for justice. As for the arrest warrants, yes, it's an odd thing. You know, when the state of Palestine acceded to the Rome Statute of the International Criminal Court some years ago, one of the first issues that arose was objections by various Western states, including my own in Canada. They objected on the ground that the state of Palestine was in fact not a state, and only states can sign treaties or accede to treaties, and in this case, the Rome Statute. And Palestine's not a state. And they argued, among other things, that, and they failed in this argument, that there's an agreement between Israel and the Palestine Liberation Organization, being a conglomeration of agreements, the Oslo Accords, that don't furnish the purported Palestinian Authority with any right to try Israelis for anything that they may do, including Israeli soldiers, in the occupied Palestinian territory. So how, even if Palestine is a state, and even if they have acceded to the Rome Statute, giving the court jurisdiction, however can it be, argues the United Kingdom and a few other Western states, however can it be that the state of Palestine can grant the office of the prosecutor of the International Criminal Court with authority to adjudicate and investigate alleged violations of that Rome Statute committed by Israeli nationals in the territory of Palestine, if the state of Palestine or the Palestinian Authority itself doesn't even have that authority under Oslo? This is a spurious argument, and it's spurious, and it has already in effect been dealt with, well, not directly dealt with, but by the pretrial chamber some 2 years ago, 2 or 3 years ago. But it's spurious on the substance for the following reason: that the agreements struck by the PLO and Israel through Oslo were meant to be temporary. First, they didn't set in stone what the rights and obligations were of both of these parties. And note, in addition, if you measure up the Oslo Accords with, for instance, the Fourth Geneva Convention and broader principles of international law, you'll see that the Fourth Geneva Convention does not admit of the prospect that any separate agreement can be struck between the representatives of an occupied population and the occupying power that violate the rights of the occupied population. See Article 8, Article 7, and Article 47 of the Fourth Geneva Convention. That is to say, that to the extent that the Oslo Accords reify, crystallize a situation where the occupying power can take advantage of its position and do whatever it wants in the territory, and the occupied population has given up certain rights that it has, for instance, not to be settled, right? Those elements of the Oslo Accords are not at all binding under international law. They're invalid. And I predict that if this jurisdictional argument is allowed to run its course, the court will reaffirm that it is of not any value. It will dismiss it and will press on to say that the whole of the occupied Palestinian territory is the territorial scope within which the office of the prosecutor has the right, and the ICC has the right to adjudicate matters.
That's very reassuring, Ardi. We're going to turn back to Evelyn in 1 second, but just to say that the Balfour Project has sought to invite David Lammy to withdraw that Sunak application to the ICC, and we await the outcome of that request, which is not just made by the Balfour Project. But Evelyn, over to you for the Q&A.
Thank you very much for that. Yeah, fantastic discussion. I encourage everyone to gather your thoughts. Oh, okay. One question has just come in. Okay, this is from Graham Jones. He says, does international law extend the right of self-determination to persons driven from their homes and now resident in refugee camps, principally in Lebanon and Jordan, and to their descendants?
Yes, it does, to the extent that those people, which clearly are part of the Palestinian people, they have a right to self-determination. And they would exercise that right in accordance with Palestinian law, including the right to return to their homes if indeed they choose to return to the future Palestinian state, or indeed as individuals to return to the homes from which they were ethnically cleansed in 1948, or their descendants were ethnically cleansed in 1948. That last bit, if they were to return to their homes in what became the State of Israel, that wouldn't necessarily be an expression of their right to self-determination as such. It would be an expression of their human rights, not to be arbitrarily deprived of their right to nationality and their right to return to their homes and so on, in line with international refugee law and international human rights law. But yes, those people are included in the Palestinian people who have a right to self-determination.
Ardi, while our friends online are gathering their thoughts and coming up with questions for you, let me ask one that must be on many people's minds today as they watch the horrors that are taking place in Gaza. You refer briefly to ethnic cleansing. That's a general phrase that we can all understand, but there are so many individual war crimes that are being recorded, that are being noted, that are being seen, and so many people who will be hoping that justice prevails eventually. Could you speak to the process by which this might happen? Do we, as part of the international community who are concerned about what's taking place, need to wait for internal Israeli processes to work through their course of actions, that the IDF's military legal investigators have to first do their course and then go to the Israeli civilian courts before any international judicial mechanism can take effect? Could you talk us through what are the potential routes by which accountability can happen?
Great question, Andrew, for which thanks. You mentioned the process. I would just offer the following word. I would say processes, plural. There are many, multiple processes by which justice can be had, and enforce a cost on those intransigent actors who persist in their violations of international law with reckless abandon, including in Gaza. The first place to look is domestically. So in most modern states, including the United Kingdom, but I include Canada as well, there are domestic pieces of legislation that make it illegal for either nationals of the state, United Kingdom nationals, to either engage in or support, to aid or abet the commission of war crimes, crimes against humanity, and indeed genocide. In Canada, for instance, we have the Crimes Against Humanity and War Crimes Act. I presume there's similar legislation in the United Kingdom, which incorporates the United Kingdom's, and in this case, Canada's obligations under international criminal law and international humanitarian law to prosecute or extradite those persons who order or aid or assist in the commission of war crimes, crimes against humanity, and so on, domestically. So there's just one example of things that can be done. Looking internationally, we have the obligation under the Genocide Convention to not only not engage in genocide, but for states parties to the Genocide Convention to prevent genocide. That word prevention implies that action is required before genocide crystallizes, before it actually happens. So if there is a real and substantial threat that genocide is about to take place, if there is reason to believe that there is a plausible threat that genocide may take place, that triggers the obligation of states parties to the Genocide Convention, including the United Kingdom, to prevent genocide. What does that mean? Ending the arms transfers. Stop providing Israel with diplomatic support at the General Assembly and other places internationally to support what they're doing, and that sort of thing. So there are many, many different processes available, including for men and women of conscience at the Balfour Project and affiliated with the Balfour Project to plug into. It's very hard to map them all. There's just so much going on, but they're there. And of course, you need to find the entry points for action domestically or internationally, oftentimes through a state or groups of states who are willing to act to press. Yeah, and I could speak for hours on that.
Evelyn, do you have questions that you want to feed through to Ardi from our friends?
I think everything's been explained so perfectly that we don't have a huge amount of questions. There's one that's just come in actually. Could you say something more about what is the counter argument / narrative of Israel to all the various violations of international law and rulings of the UN, like transfer of prisoners, house demolitions, or incidents of apartheid? Does Israel just say that the UN is totally prejudiced and can never rule fairly, and therefore they will disregard such rulings?
Yeah. So the question is so broad that it doesn't admit of an easy answer, because I couldn't possibly and reasonably deal with every response that Israel might give in respect of every violation that it has committed. But there are, and it's intimated in your question, there are broad streams of thinking that the Israelis appear to offer. And these days, it is along the lines of that which you've identified in your question, to just dismiss the United Nations and its systems, its processes, the General Assembly, the International Court of Justice, to dismiss what they say, the special rapporteurs on human rights and the OPT, to dismiss what these multiple bodies have to say on the basis that they're anti-Semitic or biased or what have you. That is to say, they don't bother now dealing with the merits of the claims being made that Israel is engaged in violations of human rights or this particular body of law, because there is no real argument to support them. I gave you one example on the continued applicability of the Fourth Geneva Convention and the occupation of the OPT. There was a point in time where creative legal argument was offered by Israel and its supporters in defense of its position, but now really the fig leaf of any pretense to adherence to international law has been ripped and torn asunder. They don't even bother doing that. They just rather say that there is no argument because this is a biased organization that is predisposed to criticizing Israel.
Okay. I wonder whether I can chip in while again our friends are thinking what to put in the chat. But if I can chip in on our new government here in the UK, just to ask a question about the principles that they have uttered, they've said they will adhere to, which is the rule of law. We have a foreign secretary who's a lawyer. We have a prime minister who's a lawyer. That remains to be put into effect in terms of policy. The manifesto of the Labour Party talked about recognition of the state of Palestine and talked about trying to restore the rules-based order and putting legal principle at the heart of policy. I don't have a specific, Ardi, but from your perspective, looking at what can come from a British government, which is a member of the P5, what would you say is the expectation, and where would you put the bar, if you understand me? Where would you put the bar that they should clear in order to put into effect the principles that they say they're going to adhere to?
Yeah, no, great question. I think that bar we've long passed it, and it's hard to even articulate what the bar is, given the enormity of what we're seeing taking place on the ground right now. In real time, we have a situation where the principal judicial organ of the International Court of Justice has declared is a serious risk that the rights claimed by South Africa are plausibly being violated by Israel under the Genocide Convention. That is to say that Israel is plausibly committing genocide in the territory. If that doesn't spur action on the part of third states, politically, legally, or otherwise, then I don't know what is. I think that the United Kingdom government should immediately and without delay recognize the state of Palestine at the very least, and send a message to the Israelis that notwithstanding your attempt to ethnically cleanse and drive the population of the Gaza Strip out of the Gaza Strip, which they are doing openly, and they declare it, right, in both word and deed, at the very least, it could be more than that. Notwithstanding that, the international community will not recognize the results of any of that. And in fact, the international community is going to affirm its commitment to a two-state solution. including by recognizing the state of Palestine. Will that, of course, will recognition of the state of Palestine bring the Palestinian people's lives back from in the Gaza Strip? Absolutely not. Will it end the occupation immediately? No, it won't. But what it hopefully will do is produce costs that then flow in the bilateral relations between this recognizing state, in this case, the United Kingdom and Israel, that can help adjust the political calculation made by Tel Aviv as they persist in their actions. In the face of silence and failure to act, even on recognition, or even in withdrawing, for instance, the application made by the United Kingdom before the International Court, the International Criminal Court, to challenge jurisdiction of the court on the basis of Oslo. If they don't withdraw that, if they don't do the basics, if they just sit back on the fence, then that will leave Israel with a simple message that they can persist, and in this case, persist in the worst and most heinous deeds known to man. That can't lead anywhere but to oblivion.
Ardi, I'd like to come back to the threat of individual legal accountability as a potential deterrent against further war crimes being committed, and to ask you if, say, someone was a dual British-Israeli citizen who is serving in the IDF at the moment in Gaza and has been alleged to have been involved or as part of a unit that's been involved in war crimes that have been reasonably well documented. How do we bring about some form of accountability here? Is this something for the British domestic courts? Is it a private actions that should be taken? Is it something that the Attorney General in the UK should announce that people who had committed such crimes could potentially face prosecution in the UK?
Yes, take what I say with a grain of salt, Andrew, because I'm not counsel in the United Kingdom. I don't know United Kingdom domestic law, but my inclination is, based on what I know here in Canada, which bases itself on English law as well, is yes, yes, and yes. I mean, so if there are dual nationals fighting in Gaza on behalf of foreign armies, say in this case Israeli army, there's nothing to stop the United Kingdom authorities, because they are parties to the Rome Statute of the International Criminal Court, to press charges against those, or to investigate those of their own, from their own nationals, for allegedly committing war crimes against humanity and other such in the territory. As to how procedurally that takes place, I would have to refer you to local counsel in the United Kingdom, whether there are private prosecutions available, or whether or not you would need the AG and or his designate to press charges is another matter altogether. I won't offer an answer there, but yes, there's no reason in principle while dual nationals cannot be on the hook domestically on the basis of one or more of their national affiliations or connections.
Well, as it happens, the brand new Attorney General here is indeed a human rights lawyer and someone who is of Jewish faith also, who's been quite outspoken about Israeli practices.
No, hopefully that's a good news for us all. Yeah.
I might come in with just one last question if we've got time. It's about the ICC arrest warrants. Will these be binding for states to implement, or are there legal loopholes that will be able to be exploited?
Well, once, on the assumption that the court affirms the request of the Office of the Prosecutor to issue arrest warrants for the 2 Israelis and the 3 Palestinians that are named, once that confirmation is given, that would be binding on all member states to the Rome Statute, on all parties to the Rome Statute of the International Criminal Court, including, among others, the United Kingdom, Canada, Germany, and so on. And so if for any reason after those arrest warrants are issued, those named individuals in the arrest warrants find themselves in the territory of a state party to the Rome Statute, that would trigger that very presence would trigger the obligations of the state party to arrest and extradite. That's the first proposition. The second thing is, are there loopholes? You bet your bottom dollar there are. And the United Kingdom is now in the process of trying to find a loophole to get the International Criminal Court pretrial chamber 1 to determine that it doesn't have the authority to issue arrest warrants in respect of only 2 of those 5 named individuals, those 2 being the Israelis, Bibi Netanyahu and Yoav Gallant, the defense minister. And I don't think that they have a very strong argument to make, but they're making it nonetheless. Jurisdiction arguments will continue to be made. Even after arrest warrants are issued, let us assume that somebody is arrested, actually arrested, and brought to The Hague, more jurisdictional arguments will be made of the sort that we've seen already with the Oslo Accord argument. And that's because of the inherent protective nature of criminal law and the strength of the presumption of innocence, right? Where those persons who are presumed innocent until proven guilty will always have the opportunity to raise jurisdictional arguments in their defense, and even nuanced jurisdictional arguments that have been made previously. But anyway, so that doesn't mean that justice won't be done. I would also like to say the following, if I might, in view of the fact that we're almost toward the end. International criminal justice is important. It's vital. But it doesn't deal with the structural issues at play between Israel and Palestine. So even in the best case, you might have 1 or 2 or 3 people who have the book thrown at them and they get incarcerated, a very tall order, given the facts that we have now, right? But even if assuming that that takes place, that's one thing. But does that structurally change or alter the trajectory of things on the ground in Israel, Palestine? I would put it to you that international criminal justice has its limitations. So too does the work at the International Court of Justice. But I think what we all need to keep in mind is that we should accept the limitations of what international law can do, but always acknowledge that law matters, and then view each of these actions, each of these entry points, as tools in a larger toolbox aimed at bringing peace towards the people of that blighted region, first and foremost for the Palestinian people who are now suffering that which they've never seen in their history, a plausible genocide in the Gaza Strip and an attempt to do away with them and finish the job on them from 1948.
Ardi, I think that sober note is probably where we're going to have to end, because we are running out of time. And I suspect that our friends are anxious for their dinner. It's not because of lack of interest in what you've had to say that they haven't been posing so many questions, but it's really been a masterful performance. So thank you so much. We've really benefited a great deal from your presence here today, and we hope that we'll be able to have you back again one day.
I should like that very much. Thank you very much for your time. I wish you all well, and keep fighting the good fight, friends.
Thank you very much.
Thank you, Ardi.